My name is Malia Haskins, and I'm a wealth strategist with RBC Wealth Management. I work with our advisors as part of their team regarding wealth transfer strategies, and I really do appreciate you taking time out of your busy day to participate in our discussion about creating purpose and fulfillment in wealth with family legacy planning. Now, many of you may have already engaged in some form of traditional estate planning. You have wills, trusts, and powers of attorney, which is an excellent step toward transferring assets to your heirs. But how confident are you that your current estate plan will put your children or even grandchildren in a position to be successful with their inheritances? Is your current plan reflective of the most current income and estate tax laws? Do you know whether you will be able to live your desired lifestyle going forward and pass wealth to family and charity when and how you wish? If you're not able to answer yes to these questions, chances are you and your family could benefit from a comprehensive legacy plan. Our statistics show that while over 50% of our clients have a will in place, more than 70% of our clients do not have a comprehensive legacy plan in place, and 32% have done nothing in the way of estate planning. No matter which category you might be in, it's not too late. Today, we'll learn more about how legacy planning can work for you and your family and touch on 3 timely strategies families are using today as part of their suite of strategies for legacy planning. At RBC Wealth Management, your financial well-being is our first priority. We're deeply committed to responsibly managing the wealth you entrust to our care. Our comprehensive wealth management process begins with your goals. Clients can expect to be treated with honesty and respect. We pledge to, number 1, put the interests of our clients first. We'll be transparent, and we offer the strength and stability of our parent company, RBC, a global leader in diversified financial services. Here are a few examples of how we help our clients. Together, we create a purposeful and prosperous future for you and your loved ones. We protect your family's financial security, and we preserve your legacy for generations to come. We will give you to the people and causes most important to you. We'll help you give to the people and causes most important to you. And our process helps to simplify your complex financial affairs. We help you achieve your retirement dreams, and we help you organize your estate. Additionally, we educate beneficiaries, children, other family members, and friends who are beneficiaries, so that they're prepared for their inheritance. These steps are all part of a legacy plan. A legacy plan is truly less of a plan and really more of a process. Creating a legacy plan requires a team of advisors who collaborate to refine and revise the strategies and structures that will benefit your family as your family grows and changes over time. The right process and legacy team will not only ensure your legacy plan evolves with you, but that it will propel your evolution forward so that you can achieve your greatest legacy and success. We take a disciplined approach to legacy planning that begins with you, your goals and priorities. It includes taking your full financial picture into account and results in a personalized wealth plan designed to achieve your financial vision. Your family will benefit from our proven wealth planning process. It begins with a conversation about your current financial situation, and from there we create a customized plan designed to meet your goals. You'll have confidence in your future and how your wealth is being managed, and with how your wealth will be available for the benefit of the charities, family members, and friends. Everyone should have an estate plan. You want to have your assets distributed according to your wishes, but how and when you choose to distribute your assets needs to be done in the context of an overall plan that takes into account current and projected net worth, your desired lifestyle, and the target value of wealth that you want to leave to your beneficiaries. Wealth transfer strategies include estate and legacy planning, charitable strategies, education funding, intergenerational planning, Life insurance can be part of the picture, and business succession planning for business owners. By engaging in the process of legacy planning, your family will benefit by having the right strategies and the tools to fit your needs. You'll have estate planning backed by a complete understanding of the whole range of your wealth, and by an institution committed to your wishes, your family, and your community. You'll feel assured with the knowledge that your children understand your values and the legacy that you're leaving. Our goal is to design, implement, and then maintain your legacy plan to accomplish your family goals and to pass on your family values. But we also want to create a plan that will pass assets as efficiently and as effectively as possible. So we need to take into account the tax implications of the strategies that we're considering. There are potentially 3 federal wealth transfer taxes that can impact your estate planning: federal estate tax, gift tax, and the generation skipping transfer tax. Additionally, the income tax implications of your estate plan need to be considered as well, both federal and state. As you can see, currently the federal estate tax exemption is $11.4 million per person, which means that a couple has 2 times that amount, basically $22.8 million worth of assets that they can transfer during life and at death without having to pay federal estate tax. Additionally, the generation skipping tax and the gift tax exemptions are currently in sync with the federal estate tax exemptions. And the annual gift tax exemption, which is the $15,000 that you can give to as many people as you want without any transfer tax consequences. There are 17 states and the District of Columbia that impose some form of transfer tax, either estate or inheritance tax. And that's on top of the federal estate tax, or in addition to. Connecticut is the only state that imposes a gift tax on lifetime gifts. So if you are a resident of one of these states, your planning will also need to take into account the state's taxation scheme. Your advisor team will help you design your estate plan. Ideally, your attorney, your CPA, and your financial advisor will collaborate to determine what type of estate plan makes sense for you, considering your comprehensive financial plan as well as your legacy goals. Typically, there are 4 documents that make up the foundation for an estate plan: a will, a revocable trust, financial durable power of attorney, and a healthcare directive, or oftentimes referred to as a healthcare power of attorney. The will is simply the legal document that gives the direction for how probatable assets are to be distributed. Probatable assets are typically those assets that are owned individually and that don't pass by law. So for instance, if you own something joint tenants with rights of survivorship, by law, it passes to the surviving joint tenant or joint owner. Life insurance, IRAs, annuities, those are assets that pass by virtue of beneficiary designation. You name individuals to be the recipients of those types of assets, and they pass outside of probate. But things that are owned individually are potentially subject to probate, and as we all know, probate is a process and there are costs that are associated with it. Revocable trust is created during lifetime and assets are transferred into the trust ownership. A revocable trust structure takes assets out of the probate process. The ownership in the trust removes the assets from being subject to probate. Revocable trusts are flexible, and for all intents and purposes, assets are treated like they are owned by the trust creator, who's also referred to as the grantor. The income within the trust, or the income generated by assets within the trust, is reported on your 1040. You can simply change or revoke the trust, put assets in and out of it. The key components for a revocable trust are the trustee, the individuals, or a professional trustee who steps in to manage assets that are owned by the trust. Then if an individual is named and then they can no longer serve in that capacity, who's the successor trustee to step in and manage asset? Who beneficiaries are? Is it family? It can be friends. It can even be charity. That basically the trust provides a blueprint for how assets are to be managed and distributed. The third document is a durable power of attorney, which gives somebody legal and financial authority over assets that are owned individually, not in trust. And this is important if disability or incapacity strike. Durable powers of attorney vary from state to state. Then healthcare powers of attorney and healthcare directives. They allow you to appoint someone to make medical decisions in the event that you can't. The document allows you to express your wishes for medical care, and then the designated agent will carry out those wishes, again, in the event that you're not able to do so. Estate and legacy planning is truly a process and needs ongoing maintenance. For many individuals, the foundational estate plan that we just talked about, those 4 cornerstone documents, will accomplish the goals for the family. However, for some families, their objectives combined with their overall financial plan and current tax laws are also additional strategies also become part of their legacy plan. On this graph, we're highlighting that there are a variety of strategies that can be used to give to family and charity. We're not going to talk through all of these, and I certainly wouldn't anticipate that you would be able to interpret what the various acronyms mean. But the purpose in illustrating this is just to basically show that the strategies on the graph highlight as the complexity of the strategies increases, so does the potential benefit to family, but the economic and legal risks also increase. So how would you know which of these strategies is right for you and your family? Well, that's where legacy planning in collaboration with your professional advisory team comes into play. As we've just seen, there are numerous strategies that could be considered as part of a legacy plan, but today we want to highlight 3 strategies. These strategies may or may not be appropriate for you to meet your family's overall goals and objectives, but for many clients we work with, we have found these to be worthy of consideration. We'll focus primarily on 2 lifetime gifting strategies to take advantage of the larger transfer tax exemptions that are currently in place. And we'll also look at a strategy for giving to charity that is in favor due to the income tax law changes as a result of the Tax Cuts and Jobs Act, or TCJA, of 2017. So a quick recap: federal estate tax, gift tax, and generation tax exemptions were significantly increased with the TCJA. But the current legislation is set to sunset in 2026. And if no new legislation is enacted, the exemption is reverting back to roughly $6 million. And that is, not to get too technical, but it's really the $5 million exemption, inflation adjusted out to 2026. And we're anticipating that that would equate to around $6 million. So the opportunity to give away almost $23 million per couple could almost be cut in half. One strategy worth considering allows married couples to make a larger gift to take advantage of the larger estate tax exemption. The strategy is called a Spousal Lifetime Access Trust, or a SLAT for short. A Spousal Lifetime Access Trust is an irrevocable trust for the benefit of one spouse, created by the other spouse. The spouse who creates the trust, the grantor, makes a gift to the SLAT using all or a portion of their estate tax exemption. The gift to the irrevocable trust removes the assets from the grantor's estate, but allows his or her spouse access to the trust assets during their lifetime. Children, grandchildren, and future generations may also be named as either current or remainder beneficiaries. When the SLAT will continue beyond the lifetime of children, there are also generation skipping tax considerations that must be factored in. For a couple with a net worth of $40 million in 2019, they have a combined exemption of $22.8 million, leaving $17.2 million exposed to estate taxes. Should the exemption fall to $12 million or $6 million each in 2026, the assets exposed to estate tax would be $28 million. If they were to each set up a SLAT in 2019, they would potentially remove an additional $10.8 million from being exposed to estate taxes. At a 40% tax rate, that's a savings of $4,320,000. In states that have a standalone estate tax and no gift tax, SLATs provide the added benefit of sheltering SLAT assets from estate inclusion for both the grantor and the beneficiary spouse at the state level. This can create a significant savings for the family, especially while there's a higher federal exemption. SLATs may be taxed as grantor trusts for income tax purposes if they're structured appropriately. What that means is that the trust is not taxed at the trust level because the income tax liability flows back to the grantor and is reported on their individual return. And this is beneficial because irrevocable trusts are subject to tax at a very compressed marginal rate structure. Once the income within a trust reaches about $12,000 of taxable income, it's subject to tax at the highest marginal ordinary income tax rates and capital gains rates. Since taxes are paid outside of the trust then, under this SLAT structure, the trust has the potential to grow without the burden of income taxes. In addition, the payment of taxes by the grantor is not considered an additional gift to the SLAT. While individuals may transfer any asset into the SLAT, we generally recommend gifting assets that are expected to significantly appreciate, thereby increasing the wealth transfer benefit. In addition to federal gift and estate tax, there's another federal transfer tax called the Generation Skipping Transfer Tax, or GST. This tax applies when a transfer is made to somebody called a skip person, and that's someone who is 2 or more generations below. For instance, grandchildren and great-grandchildren. The GST tax is a flat tax equal to the highest gift and estate tax rate that's then in effect. In 2019, that's 40%. And it's imposed on any transfer, a direct skip, a taxable distribution, or a taxable termination that's made to a skip person. For example, if you make a gift of $1 million to your granddaughter in 2019, the applicable GST tax would be $400,000. It should be noted that the GST tax is in addition to any gift and estate tax that must be paid. GST tax and gift and estate tax can consume a substantial portion of the underlying transfer. Keep in mind the generation skipping exemption is currently $11.4 million. So the $400,000 GST tax that I referred to just a bit ago would not be in effect until such time as you had exceeded the $11.4 million exemption by giving away $11.4 million that would qualify as a generation skip. One of the most important or common uses of a generation skipping trust is to provide income to children while ultimately transferring the assets to grandchildren or even lower generations. If the trust is drafted properly, children can receive all income from the trust for their lifetimes without the assets actually being included in their gross estates when they die. A typical trust provides that when that last child dies, then the assets in the trust are distributed to grandchildren. In some cases, the trust will be drafted for as long as legally possible. In some states, trusts could virtually last forever. Each generation would then be receiving income from the trust, but the principal would not be distributed. This is what's oftentimes referred to as a dynasty trust. As many of you, most of you, probably all of you are aware, in December of 2017, President Trump signed into law the TCJA, and it was one of the most dramatic changes to the US tax code in over 30 years. There were significant changes that impacted individual taxpayers, including lower marginal rates and higher brackets of income. Many individuals who itemized deductions under prior law are now taking the standard deduction, which is $24,400 per couple this year and $12,200 per individual. Some individuals, as a result, pay less in overall income tax. Other individuals were negatively impacted and paid more in income tax. Because every taxpayer is unique, it's really difficult to come to one conclusion. And that conclusion, I guess, that I'm referring to is whether or not the Tax Cuts and Jobs Act was truly a tax cut for most tax-paying individuals. But it's really dependent on everybody's individual circumstance. The good news under the TCJA is that charitable deductions survived and remain deductible as an itemized deduction. There were several itemized deductions that were eliminated or altered. State and local taxes are now limited to $10,000 per taxpayer. That's that SALT limitation that I'm sure many of you have heard of. So for those taxpayers that are in high income tax states, the SALT limitation was a negative change. Mortgage interest survived, but the cap on the amount of debt for which the interest can be deducted was lowered to $750,000. That came down from $1 million. But prior loans prior to 2017, are grandfathered in. Home equity interest is also no longer deductible for the most part. However, charitable contributions are fully deductible, subject to the limits that exist under prior law. For gifts of capital assets like real estate or stock to public charities, there's a limitation for deductibility on an annual basis, and that's 30% of adjusted gross income. For cash contributions to public charity, it's a 60% AGI limitation. It had been 50% under prior law, and the TCJA increased it to 60% of AGI. Any excess or unused deduction can be carried forward for 5 years. So what that means is that if as a result of the 30% limitation for adjusted gross income, some of the charitable contribution was not able to be deducted in the in the tax year, any unused deduction can be carried forward for 5 years. So due to these and other changes, many taxpayers will wind up taking the standard deduction and will no longer itemize. If your itemized deductions are close to the standard deduction of $24,400 for married filing jointly or $12,200 for individuals, one strategy is to consider bunching your charitable deductions so that you can itemize and get a benefit from the charitable gift. Let's walk through an example. So Mary and Jim, they're a married couple, they're filing jointly. Mary and Jim's SALT deduction is the full $10,000. They have mortgage interest of $6,000, and they've typically given $5,000 annually to charity. So their total itemized deductions would be $21,000. The standard deduction is $24,400. So they would take the standard deduction of $24,400. However, their charitable contribution of $5,000 doesn't impact their income tax scenario. Alternatively, if Jim and Mary were to bunch or to accelerate 5 years of their charitable contributions into 1 year, then their itemized deductions in year 1 would be the $10,000 salt salt deduction, $6,000 for mortgage interest, and then $25,000 for their charitable contributions, for a total of $41,000. So instead of taking the standard deduction, they would itemize and take the $41,000 deduction. Instead of giving the $5,000 annually with no income tax benefit, the $25,000 larger gift in year one gives them the ability to itemize above the standard deduction and makes the charitable gift more efficient. But what if Jim and Mary wanted to continue their annual pattern of giving to charity? One option for them to consider would be to make the donation to what's called a donor advised fund. A donor advised fund is an individual fund or a private charitable account that is created under a larger charitable organization, like a charitable trust or a foundation. It is much simpler to create and administer than a private foundation, but it can be used in a similar manner, in that a donor advised fund makes a gift and then the donor can make recommendations out of the donor advised fund to benefit the charities of their choosing. In our example about bunching charitable deductions, the $25,000 contribution in year one could be given to a donor advised fund, and then each year the advisor, the family, the individual, Jim and Mary, they could make recommendations to the donor advised fund about how much to distribute and to whom to distribute. And if they wanted to continue their pattern of $5,000 annually, they could make a recommendation that $5,000 out of the donor advised fund be distributed to charity or charities of their choosing. As you noted, I'm saying that the donor has the ability to make recommendations, and that's true. The donor doesn't have complete discretion as to whom can be the recipients of the charitable distributions out of the donor advised fund. However, the criteria that the overarching organization, the governing charitable trust, what they're looking for is whether or not the recommended charity is a qualified 501c3 charity. And so in my experience, I have rarely seen a request for a distribution from a donor advised fund denied. And if there is an issue, we often work with the charitable trust to come up with a way to accomplish the overall charitable objectives of the family in a creative way. With the combination of bunching deductions and contributing the bunch deductions into a donor advised fund, you might be able to make your charitable contributions more tax efficient and continue an annual pattern of giving to charity. Now, shifting gears just a little bit, we're going to talk about what the wealth transfer plan or estate plan means for your family. Getting your plan in place with wills, trusts, powers of attorney, and maybe additional strategies is excellent progress in getting your legacy plan in place. But it's not a complete wealth transfer plan unless your family and other beneficiaries have some understanding of what your plan is for your assets. What your purpose for your wealth will be once you are no longer able to manage and control your wealth. Preparing your beneficiaries to inherit is also an important part of legacy planning, and I would say one that's typically been overlooked. Putting your children and grandchildren in a position to be good stewards with the money and the assets that they inherit is critical to ensuring that they will be successful at protecting and preserving assets and to carry on the legacy your family wants to carry forward. Working with your advisory team, you can develop a way to communicate your estate plan to your children and possibly even grandchildren, whether that's a family meeting or one-on-one meetings with individual beneficiaries. Our advisors can help ensure your beneficiaries are educated and incentivized by the things that are important to your family. A comprehensive legacy plan has many facets. The documents and the structures that lay out your plan, wills, trusts, powers of attorney, healthcare directives, the solutions or assets that are used to fund these structures, to fund the plan, whether that's stocks, bonds, life insurance, annuities, all of that needs to be coordinated. How assets are owned, how beneficiaries are named, and where assets pass when certain trigger events happen is critical, and it may change over time. For business owners, a succession plan, what happens to the business? That's critical. And educating beneficiaries is also a crucial step in the process. Managing the plan, making sure it stays current with regard to estate tax laws and with regard to your family as the goals, as your family evolves and changes and your goals and objectives change, making sure how you own your assets and coordinate with the plan as your asset base changes and evolves is critical to ensure that your plan is as efficient as possible. We do the right thing, holding ourselves to the principle that fulfillment for clients comes from how their wealth is built as much as knowing that it serves a good purpose. We're committed to delivering meaningful and measurable results and dedicated to helping you achieve your goals. Our commitment to our clients is that we'll help achieve goals financially and find greater fulfillment in your overall wealth. Thank you so much for your attention this afternoon, and have a fantastic remainder of the day.
Great. Thank you, Malia. I'm going to open up the lines for any questions that our attendees have. We'll give it a few minutes and let those questions start rolling in.
Malia, we have a question. How do someone maintain the 4 tools or artifacts of the foundational estate plan?
How does someone maintain those?
Correct.
Yeah.
The 4 tools or artifacts of the foundational estate plan.
Yep. Excellent question. And it's really part of the legacy planning process. So what our team does on a regular basis is to review existing documents that are in place in conjunction with how assets are owned. And also in the context of the comprehensive wealth plan that we do for our clients. So understanding, where clients are currently. Oftentimes we find clients have done planning and it was done, years ago, maybe, 5, 10 years ago even, and their situation has changed significantly. And tax laws may have changed as well as the assets that they own. And so conducting a review, I would say at least every other year, unless there's a significant change in the tax laws or a significant change within the family. If there's been, divorce, marriage, maybe potentially a death, those trigger events, I think, are an impetus to take a look at and kind of review and revise, if necessary, those foundational documents. And then again, part of the legacy planning is to make sure that how assets are owned syncs with those documents. I see oftentimes wonderful, beautiful estate planning documents, but not all assets may have been transferred into a revocable trust. And what happens then is that any assets that are owned individually and they're not owned by the trust would go through a probate process. And typically there's a will that would pour over those assets into the trust, because the trust is typically intended, the revocable trust is typically intended to be the primary wealth transfer document. But if assets aren't owned by it, then that probate process is necessary to get assets funneled into the trust so that the trust ultimately does distribute it. So, I hope I've answered the question, but it's really just an emphasis on continually reviewing not only the documents, but the documents in the context of the financial situation as it exists currently. Thanks. Are there other questions?
Yes, Malia. Next question is, what trust should I use if my children are too young to be able to manage money at the present time?
Yeah, that's not an uncommon scenario, right? Where you've got either children that by virtue of being, under the age of majority, they're not adults. They're too young to be able to manage money, or in some people's view, even young adults are maybe not in a position or a situation where they're ready to take on the responsibility of managing significant wealth, or even maybe if it's not significant, maybe just some an inheritance. And so using a revocable trust that owns the assets while parents are alive, but of course if something happens to the parents in the short term or prematurely, so the trust remains, the trust stays, the revocable trust then converts into what's called an irrevocable trust. And typically the grantors of the revocable trust are also serving as the trustees. So they're managing the assets as long as they're able. But if they're not able to be serving as the trustees, then naming a successor trustee, somebody or a professional trustee to step in and manage assets is critical. And who that choice is really a big discussion point. It's a big decision for individuals to make. If they're using revocable trusts, who steps in if I can't manage? Oftentimes I'm seeing the use of professional trustees. So when I say a professional trustee, that's basically an organization, a financial institution that's set up in a way that they can assume the fiduciary responsibility of serving as a trustee. Lots of benefits to that, in that you've got a professional who's stepping in, whose role is agnostic. They are objective. They are not subject to being persuaded or encouraged by other family members. They're going to make decisions that are for the benefit of the beneficiaries of the trust in accordance with the way that the trust is drafted. And the other, one of many benefits is that a professional trustee survives. It's an organization, it's a corporation, it's an entity, whereas individuals, so if you're considering, if the consideration is to name an individual, say an uncle or a trusted sibling to step in, a brother or sister that could step in for you, they have a life expectancy, whereas a professional trustee doesn't. So that's a great discussion point, one that I would encourage to have and to continue having, monitoring as part of that ongoing planning process. Is who we've named as successor trustee the appropriate successor trustee? I've seen documents that have named individuals as successor trustee, and the individuals have passed away, and so then it's a matter of updating the trust document to make sure that there is someone else or a professional trustee that can step into that role. So
Great, thank you, Malia. We have another question here. If we have beneficiaries designated on all assets and keep them updated, is the foundational estate plan still necessary?
I get that question quite often, and I think it really depends on the overall objectives. So if assets pass by virtue of beneficiary designation to individuals, you have transfer on death designations on bank accounts and brokerage accounts, what you've accomplished is avoiding probate, which is certainly an objective for many of our clients. However, those assets then pass directly to the named individuals or named beneficiaries, which may or may not be appropriate, or may not be in line with some of the objectives. So it's possible to name trusts as beneficiaries on IRAs, on other assets like annuities or life insurance that pass by virtue of beneficiary designation. What trusts do is allow for continued asset management and asset protection. And I think, there's maybe traditionally a little bit of a negative connotation with the term asset protection, but I really look at it as a positive benefit. If you've got younger beneficiaries, they may be at a stage in life where, even if they are financially savvy, they have a lot of runway in front of them, and there are a lot of contingencies, a lot of things that can happen. Divorces happen, premature deaths can happen. And so if the family objective is to protect and preserve assets for generations, the use of trusts is really a better way to accomplish that. The matriarch and patriarch of a family can get a plan in place that will benefit, children and grandchildren and potentially great grandchildren and maybe even future generations. And so the use of trusts is the way to accomplish that. But in a very simple situation where the only objective is to avoid probate, and maybe the asset base is relatively, on the smaller side, then I think the use of probate avoidance strategies like beneficiary designations to individuals, TODs, certainly can make sense. But that's really part of what we uncover with our clients as we go through the process of legacy planning.
We have another one here. Is there a way to use a trust to sell highly appreciated assets to generate income?
Is there a way? Yes, there are several strategies and structures that allow you to do that. The most common one would be a charitable remainder trust. And the reason for the use of a charitable structure is that if you have already a highly appreciated asset, it already has an inherent income tax component to it, an inherent, most oftentimes an inherent capital gain. And so if you make gifts to individuals or to trusts during lifetime of appreciated assets, unfortunately, you transfer a carryover basis for income tax purposes. And so if I were to set up a trust and say I had, stock that had appreciated from, $1 a share to, it's worth $1 million a share, that gain that's inherent in the stock, if I transfer that to a trust, the trust gets that carryover basis. But with the charitable remainder trust, the trust itself is a charitable structure. So you can transfer that appreciated security into the charitable structure. You do generate a charitable deduction for the contribution, but a very important component of that transaction is that inherent gain, that $999,000 gain is basically not subject to being recognized on your tax return. So if you transfer that stock into the charitable trust, the trust then can reposition the stock, sell it, invest in maybe something else, and that capital gain, because it's a charitable trust, the trust does not have to pay, or it recognizes the income, it doesn't have to pay gain on the or tax on the gain. Then the beneficiary of the trust during lifetime is the grantor. You potentially, you get an income stream over the period of the term of the trust, and then when the trust ends, either by virtue of death or a term of years, then whatever's remaining in trust passes to charity. So that's one way of sort of removing that large cap gain from being subject to tax in the individual taxpayer, but kind of removing it and putting it, shifting it into a charitable trust. Now, I don't want to be misleading, because the income stream that comes back to individuals, to the grantor, is a taxable income stream. So over time, some of that capital gain may be distributed back to the grantor and they pay tax on it, but it's a way to defer and maybe completely, not completely, but defer or avoid a large portion of that capital gain. So
Great. Thank you, Malia and Kyle and Jonas, for bringing this presentation to Patina Nation today. Just a quick reminder of the Patina Nation benefits with RBC Wealth Management. They provide our 401k for our members, wealth planning services, and trust planning. If you have any questions or would like to reach out to Kyle or Jonas, their emails are up on the screen. Any feedback that you have for our presenters or unanswered questions, reach out to Kyle and Jonas, and I'll leave their email up on the screen for just a moment. And thank you all for joining us today. You'll receive an email in your inbox sometime next week with a replay of this event. So if you would like to rewatch or listen to different parts of this, that will be available on patinanation.com. And you also receive that in your email. Thanks so much. Bye-bye.
This has been a presentation of the Patina Nation. To watch more content like this or for more information, please visit us online at www.patinanation.com.